The Supreme Court's Chief Justice is pushing back now against President Trump's call to impeach judges who have issued rulings against the administration's efforts.
In a statement issued today, Chief Justice John Roberts said in part, quote, "Impeachment is not an appropriate response to disagreement concerning a judicial decision," end quote. He added that the appeals process and appellate courts exist to resolve these very issues. The president and some of his officials have called for various judges to be impeached for blocking administration policies over the last few months. However, on social media yesterday, Mr. Trump himself called for the impeachment of a U.S. district judge who blocked the deportation of Venezuelan migrants. The administration also sent a letter to a federal appeals court on Monday, urging for the judge to be removed from the case.
Hi guys, Adam is speaking. So what just happened? For the first time in American history, two branches of government are simultaneously deploying their most extreme weapons against each other. A constitutional battle on two fronts at once, with no precedent for what comes next. On one side, the Trump Justice Department has directed all 93 U.S. attorneys' offices across the country to compile documentation on federal judges.
Does Albany have a top federal prosecutor? That is the question we're looking at this morning after a replacement for a Trump U.S. attorney pick was installed, then promptly fired within a matter of hours.
Yeah, CBS 6's Laura Jamat joining us live outside the federal courthouse in Albany this morning. Laura, this is a major update in a saga we've been following for months here.
An unusual move from judges here in the Northern District of New York to appoint a new U.S. attorney, citing a law that fills a vacancy when a U.S. attorney's term expires. The judges appointed former prosecutor Donald Kinsella. Just last month, a federal judge found that acting U.S. Attorney John Sarcone was unlawfully serving in the role. But the New York Times reports just hours after the court announced Kinsella's appointment, he got an email from a White House official saying he was being removed. Deputy U.S. Attorney General Todd Blanche took to social media last night to say judges don't pick U.S. attorneys, the president does, and said Kinsella was fired. Again, those judges had followed a law that specifically allowed them to install Kinsella.
Not for law enforcement purposes. Not for any legitimate legal function. To collect what one DOJ official openly called impeachment fodder in what they described as a war with the judiciary. The executive branch, the institution responsible for enforcing the law, has converted its entire prosecutorial infrastructure into an opposition research operation targeting the judges who rule against the president.
Let's talk about another issue that's been making headlines, and that is some of the actions the Trump administration has been taking against law firms that it sees as unfriendly toward it. Now, some pushback. We've got a federal judge blocking this new executive order from the president yesterday that punished one prominent law firm. That firm had successfully sued the news, Fox News, for promoting those false claims of election fraud. You might remember a few years ago. The judge called the order a, quote, shocking abuse of power. Is there a precedent for punishing a law firm for winning a case? I mean, talk about where we're at right now with this legal issue.
So this is an issue I'm obviously biased on because as an attorney and having many colleagues and friends who are in these major law firms, I guess I have to say I feel a little protective of the legal profession. So forgive my bias. But this to me is playing out exactly as I predicted or thought it might, because when you attack law firms for their exercise of their First Amendment rights. And it is clear that advocacy to a court, litigating, arguing to a judge is a form of protected First Amendment speech.
On the other side, Democrats in the House have rushed in articles of impeachment against Donald Trump. 7 articles covering abuse of power, constitutional violations, unlawful deportations, and the abuse of trade and war powers. But most significantly, articles that explicitly charge Trump with threatening federal judges and calling for the execution of members of Congress.
President Trump facing outrage from Democrats tonight after demanding the arrest of a half-dozen Democratic lawmakers, suggesting they be executed for posting this video.
We want to speak directly to members of the military.
Where 6 Democrats, all with national security backgrounds, urge members of the military to disobey any illegal orders from President Trump.
No one has to carry out orders that violate the law or our Constitution.
Referring to the video, President Trump writing, seditious behavior from traitors, lock them up, and seditious behavior punishable by death.
140 House members voted to advance those articles. They put on the official congressional record that threatening judges is impeachable conduct. And in the middle of this two-front war, Speaker Mike Johnson has reversed his previous opposition to judicial impeachment and now backs efforts to remove judges who block Trump's agenda. Senate Republicans are holding hearings on what they call rogue judges. Ted Cruz is saying that specific Trump-targeted judges meet the constitutional standard for removal. Chief Justice John Roberts has publicly warned that this campaign is dangerous and must stop. This is not a theoretical debate about constitutional theory. This is the executive branch using the machinery of government to target the judiciary. This is the legislative branch using impeachment against the executive while simultaneously enabling the executive's assault on the courts. And this is happening right now, in real time, while the midterm elections approach and the constitutional order hangs in the balance. Let me take you inside this unprecedented confrontation and show you exactly what is happening, why it matters, and where we go from here. Before we go any further, you need to understand why the Justice Department's judicial impeachment project is the single most alarming development in this entire story. When Donald Trump posts on social media that a judge should be impeached, that is constitutionally problematic. It delegitimizes judicial authority. It generates threats against judges. It signals that the executive views adverse rulings as attacks rather than legitimate exercises of judicial review. But it is Trump as a political actor making political statements. What the Justice Department is doing is categorically different. The DOJ has directed all 93 U.S. attorneys' offices across the country to compile examples of what they are calling egregious judicial decisions. They are systematically collecting documentation on judges who have ruled against the administration, specifically for the purpose of congressional impeachment referral. Deputy Attorney General Todd Blanche's office described this as collecting judicial impeachment fodder in what they called a war with the judiciary. That language matters. A war with the judiciary. The executive branch's top law enforcement officials are openly describing their work as warfare against the third branch of government, and they are using the institutional infrastructure of federal prosecutorial power to conduct that war. Every U.S. attorney's office in the country is now contributing to a database of judicial conduct being assembled for the specific purpose of finding grounds to remove judges who have been most effective at constraining the administration's most aggressive policy implementations. This is not a political research project. This is the systematic conversion of the federal prosecutorial infrastructure into an opposition research operation targeting the judiciary. It is using the same institutional network that is supposed to be dedicated to neutral law enforcement to build the case for removing specific judges from the bench for rulings the administration found inconvenient. And there is no precedent for this in American legal history. The Constitution protects federal judges through lifetime tenure and salary protections specifically designed to insulate judicial decision-making from executive retaliation. Those constitutional protections operate against official governmental action, not just informal political pressure. And this DOJ project is exactly the form of executive branch institutional action that the constitutional protections were most directly designed to prevent, using the executive's control over the law enforcement apparatus to systematically document the basis for removing judges whose decisions the executive finds objectionable. Now let me tell you about the congressional component of this judicial targeting campaign, because what Speaker Johnson and Ted Cruz are doing makes the DOJ project operationally viable rather than just institutionally alarming. Speaker Mike Johnson previously resisted judicial impeachment. He understood, at least at one point, that impeaching judges for rulings you disagree with is not how the constitutional system is supposed to work. But he has now reversed that position. He is backing efforts to impeach judges who block Trump's agenda. And his reversal matters because the Speaker controls the House floor schedule, the committee assignment processes, and the procedural decisions that determine whether any initiative reaches a formal congressional vote. A Speaker who opposes judicial impeachment provides institutional resistance to the executive's judicial targeting campaign. A speaker who now endorses judicial impeachment provides the specific procedural pathway that converts the executive branch's institutional preparation into actual legislative action targeting specific named judges. The DOJ can compile all the documentation in the world, but without House floor access, without committee scheduling, without leadership endorsement, that documentation remains advocacy rather than actionable congressional process. Johnson's reversal provides exactly what the DOJ project needs: institutional access, procedural legitimacy, a pathway from compiled documentation to formal impeachment proceedings. And then you have Ted Cruz and Senate Republicans holding hearings on what they are calling rogue judges. Cruz has gone on the record saying that at least 2 Trump-targeted judges meet the constitutional standard for impeachment and removal. Formal Senate hearings with witnesses, constitutional testimony, create the institutional veneer of due process around what is functionally a coordinated executive legislative campaign to punish judges for adverse rulings with the most extreme available consequence. 3 institutions: the DOJ compiling the evidence, House leadership providing the procedural pathway, Senate Republicans establishing the constitutional theory, each contributing a specific component to a coordinated campaign that none of them could make operational alone. That coordination is what makes the judicial impeachment campaign so institutionally alarming. It is not one frustrated official attacking judges he dislikes. It is the coordinated deployment of multiple institutional components in service of the same constitutional assault on judicial independence. Now let me flip the camera and show you what is happening on the other side of this two-front confrontation. Because while the executive and its congressional allies are targeting judges, Democrats in the House are rushing in articles of impeachment against the president himself. Representative Danadar introduced 7 impeachment articles against Trump in April, 7 articles covering abuse of power, flagrant constitutional violations, unlawful deportations in defiance of court orders, and abuse of trade and war powers. That breadth, 7 separate articles covering multiple domains of alleged constitutional violation, is the legislative expression of the comprehensive accountability case that has been building throughout the second term. But the most significant development came in December, when 140 House members voted to advance Al Green's impeachment resolution, 140 members, in a Republican-controlled House, against the Speaker's procedural resistance. That vote count is a documented demonstration of substantial congressional appetite for impeachment accountability that exceeds what the partisan arithmetic of the current chamber would predict. And here is what makes the Green resolution so specifically significant for the two-front confrontation. The articles explicitly charge Trump with threatening federal judges and calling for the execution of members of Congress as impeachable conduct. The resolution argues that Trump knows his words endanger officials and undermine democracy. And 140 members voted to advance that resolution, putting on the official congressional record that threatening judges is impeachable conduct. Think about the constitutional irony. At the exact moment when the executive branch is directing its entire prosecutorial infrastructure to compile impeachment fodder against judges who rule against the president, the legislative branch is advancing impeachment articles that explicitly cite the president's threats against judges as the basis for his own removal. The president is trying to impeach judges for rulings. Congress is trying to impeach the president for threatening judges. The impeachment mechanism is being deployed simultaneously in both directions. That is not normal politics. That is not how the constitutional system is supposed to operate. That is a two-front war where every institution is simultaneously threatened with the most extreme available accountability mechanism. Now let me tell you about Chief Justice John Roberts' role in all of this. Because the head of the judicial branch has stepped out of his traditional role to issue a warning that no one should ignore. Roberts almost never makes public statements criticizing other branches of government. He is the institutionalist's institutionalist. He believes in the legitimacy of the courts and protects that legitimacy by staying above the political fray. But Roberts broke that silence. He publicly warned that personal attacks on judges are dangerous. He said that impeachment is not the proper response to disagreement with a judicial decision. And he used the phrase, has got to stop. That is not careful, measured diplomatic language. That is a direct warning from the nation's highest judicial officer that the attacks on the judiciary have crossed a line. Roberts is saying that the campaign against judges is dangerous. He is saying it must cease, and he is saying it while the DOJ is openly describing its work as a war with the judiciary. When the Chief Justice of the United States says something like this, it is not just his personal opinion, it is the judicial branch speaking. It is the institutional voice of the federal court saying that the executive branch's attacks on judicial independence are unacceptable. It gives cover to every lower court judge facing pressure. It signals that the judiciary as an institution will support judges who rule based on the law rather than political pressure. And Roberts' warning that the attacks are dangerous is not hyperbole. Judges are receiving death threats directly tied to Trump's attacks. When Trump attacks a judge by name on social media, that judge's security risk spikes within hours. Courthouse security has been increased. Some judges have had protesters show up at their homes. Families are being targeted. When a president uses rhetoric that portrays judges as corrupt enemies of the people, that president is creating a permission structure for extremists to target those judges. Roberts is saying that cannot continue. Let me break down the specific institutional components of this two-front confrontation so you understand exactly what each side is doing. The DOJ Judicial Impeachment Project is the systematic conversion of the executive branch's law enforcement apparatus into a political weapon targeting judicial independence. All 93 U.S. attorneys' offices are now contributing to a database of judicial conduct assembled for the specific purpose of finding grounds to remove judges who have constrained the administration's policy implementations. That is a use of prosecutorial institutional resources that has no precedent in American legal history. Speaker Johnson's reversal from resisting judicial impeachment to endorsing it provides the specific institutional access that makes the DOJ project actionable. The Speaker controls the House floor schedule, the committee processes, the procedural decisions that determine whether any initiative reaches a formal congressional vote. A Speaker who now endorses judicial impeachment provides the procedural pathway that converts the executive branch's institutional preparation into actual legislative action. Ted Cruz's Senate hearings add the formal upper chamber record that makes the judicial impeachment campaign appear as a legitimate constitutional exercise. Formal Senate hearings with witnesses create the institutional veneer of due process around what is functionally a coordinated executive legislative campaign to punish judges for adverse rulings. On the other side, the Green Resolution's 140 advancing votes with articles explicitly citing judicial threats as impeachable conduct creates the documented congressional record that judicial threats constitute impeachable abuse of power. That legislative assessment made in a formal impeachment proceeding creates the most authoritative available congressional record of the constitutional dimensions of the confrontation. The Danadar 7 articles provide the comprehensive accountability framework covering multiple domains of alleged constitutional violation, each grounded in verified facts from the official record, each representing a separate constitutional offense that the House has documented. And Chief Justice Roberts' public warning is the judicial branch formally asserting that the campaign against its members is dangerous and must stop, using the institutional voice of the Supreme Court to push back against coordinated executive legislative pressure. Now let me give you the 4 points that tell you exactly where this two-front confrontation stands and where it is going. Point 1. The DOJ Judicial Impeachment Project is the most institutionally alarming development because it represents the systematic conversion of the executive branch's law enforcement apparatus into a political weapon targeting judicial independence. The Constitution protects federal judges through lifetime tenure specifically designed to insulate judicial decision-making from executive retaliation. Those protections operate against official governmental action, not just informal political pressure. The DOJ project is exactly the form of institutional executive action the constitutional protections were designed to prevent. Point 2. The Green Resolution's 140 advancing votes with articles explicitly citing judicial threats as impeachable conduct is the most significant legislative action because it creates the documented congressional record that judicial threats constitute impeachable abuse of power at the exact moment when the executive is simultaneously deploying the DOJ to compile judicial impeachment fodder. The 140 vote count in a Republican-controlled House demonstrates substantial congressional appetite for impeachment accountability that exceeds what the partisan arithmetic would predict. Point 3. Speaker Johnson's reversal from resisting judicial impeachment to backing it is the specific congressional leadership change that enables the judicial impeachment campaign by providing institutional access and procedural legitimacy. Without House floor access, without committee scheduling, without leadership endorsement, the DOJ's compiled material remains advocacy rather than actionable congressional process. Johnson's reversal provides exactly what the campaign needs to move from preparation to action. Point 4. Here is what we need to watch as the confrontation continues. Whether the DOJ project produces formal impeachment referrals of specific named judges to the House Judiciary Committee. Whether the 140 votes that backed the Green Resolution can be converted into a floor vote through whatever procedural pathway becomes available. Whether additional public statements or formal judicial branch institutional actions escalate the judiciary's own resistance, and whether the documented two-front impeachment confrontation becomes politically salient for voters evaluating candidates who have enabled the judicial targeting campaign or opposed it. So here is where we stand. The Trump Justice Department has directed all 93 U.S. attorneys' offices to compile judicial impeachment fodder in what officials describe as a war with the judiciary. Speaker Johnson has reversed his opposition and now backs impeaching judges who block Trump's agenda. Senate Republicans are holding hearings on rogue judges, with Ted Cruz saying specific Trump-targeted judges meet the constitutional standard for removal. On the other side, Representative Danadar has introduced 7 impeachment articles against Trump covering abuse of power, constitutional violations, unlawful deportations, and abuse of trade and war powers. The Green Resolution advanced with 140 House votes, with articles explicitly charging Trump with threatening federal judges and calling for the execution of members of Congress as impeachable conduct. Chief Justice Roberts has warned that personal hostility toward judges is dangerous and must cease. The impeachment mechanism is being deployed simultaneously in both directions: executive against judiciary, legislature against executive. In the most extraordinary two-front constitutional confrontation of the modern era, the executive branch has converted its law enforcement apparatus into a weapon targeting judicial independence. The legislative branch is advancing impeachment articles against the president for threatening judges, and the judicial branch is watching its institutional authority attacked from both sides. This is not a theoretical debate. This is not academic constitutional discussion. This is happening right now. The DOJ is compiling files. The House is advancing articles. The Senate is holding hearings. The Chief Justice is issuing warnings. And the midterm elections are approaching, which means the voters are about to have their say on which side of this confrontation they support. We are going to be right here covering every development as it unfolds: the DOJ referrals, the House floor votes, the judicial responses, the election outcomes. Because this is the moment when we find out whether the constitutional system can withstand a two-front assault from both ends of Pennsylvania Avenue, or whether the impeachment mechanism that was designed to be the Constitution's most extreme check on power becomes instead the weapon that tears the system apart.